Namaskar. A very warm welcome to each and every one of you to day 3 of our online lecture series. This series has specially been organized by Akhil Bharatiya Adhivakta Parishad. And before we go on to our lecture, let me first remind everyone that today is 22nd April and this is the International Earth Day. And we all know as soon as we had our pause button because of the lockdown, our Mother Nature, our Mother Earth, is on a fast forward mode of regenerating itself. We can all see and just we have already realized that the pollution levels have gone below. We all in Delhi, we know the AQI has gone below as much as 37, 40, 45. We have never seen that in the recent future, in the recent past. Today is day 3, and the topic today of our lecture is conducting criminal trial through video conferencing, the challenges and opportunities. Today's lecture is being delivered by our famous senior advocate, Mr. Sidharth Luthra, and we all who are so regular in seeing him in the courts in Delhi, in Supreme Court or High Court, let me just tell you beforehand that he is before us today with a very fresh and new look. May I please welcome Senior Advocate Sri Sidharth Luthra to join the lecture series. Namaskar, sir.
Namaskar. Good evening. Namaskar. Good evening. कैसे हैं आप लोग? Today I'm going to be talking about the changes that COVID has brought to us in the COVID era, which is currently, and the post-COVID era. One thing is very clear: life is not going to be the same, and especially for lawyers. We have seen how our courts have ceased to function because courts all over India, from the district court till the Supreme Court, attract crowds. However much we try, we cannot restrict the number of crowds because you have litigating parties, you have lawyers, you have the junior lawyers, you have the supporting court staff for the litigating lawyers, their clerks, munshis, and then you have the court staff present in the court who are assisting each judge. So from the trial court till the Supreme Court, there is a large paraphernalia of personnel who are required at any time to conduct proceedings. And then there are other support staff, for example, security personnel, canteens. All of these are crowds, and crowds are abhorrent to an era where we want to have social distancing. Now, we must understand that in the post-COVID era, and we hope that the lockdown will cease soon, but the reality of life seems to be that the lockdown, even if it ceases on the 3rd of May, which we hope for, the change is going to be gradual, and it is not going to be business as usual for lawyers or litigants. The Delhi High Court, I understand, has already taken a view that they will only have courts operating electronically through video conferencing, and the proceedings before those courts are going to be limited, because in video conferencing you have to have fixed time slots, and judges will not be able to do their 50-60 matters a day, those judges who are very efficient. Similarly, our experience in different courts has been, in the Supreme Court, at least my experience has been, that the connectivity time and the time to be heard take a certain slot, and lawyers have to be on standby. So these are going to lead to great changes. But that's the High Court and the Supreme Court. Let's leave them aside, because what we are concerned with is how it's going to impact a criminal trial. Because today what is most important for us is, in a proceeding where there are witnesses, where there are prosecutors, where there are investigating officers or pairwee officers, where there is court staff, police staff, where there are complainants and accused, where some people are in custody, whereas some are out, and there are defense lawyers, and there is a judge. Can we really imagine that a trial can be done as it used to be done before, when everybody would congregate, and sometimes, though not really permissible by law, more than one trial would go on in the same courtroom? So you had the reader doing one trial, the steno doing one trial, and the judge doing a third trial also sometimes, which of course we know is not legal. But that's the reality of life which we must understand. So today I'm going to share with you some of my concerns and the challenges that are going to face us in the future, and how this system needs to develop and how it's going to develop. So I've done this with a PowerPoint presentation, which I've left it to the Adhivakta Parishad to share, because these are my thoughts. I'm sure you may have better and more creative thoughts, and you who are practitioners in every court in the country will be able to understand the nuances of practicing in different courts and how these difficulties and opportunities are going to arise. But for now, I'm going to share my thoughts, and I'm going to start by, let's understand the stages of a criminal proceeding. So there are two sets. The first is the FIR gets registered, investigation, bail, etc., arrests, seizures, recoveries, filing of charge sheet, and then you have cognizance, summoning. Till this stage, an accused is either under investigation or in custody, or alternatively, the accused person is not really in the picture so far as the investigation and the court proceeding, unless he or she are called to give a statement and or arrested, as the case may be. Then you have cognizance and summoning, and then comes the stage, a very crucial stage, of supply of documents or scrutiny, section 207 of the CRPC. And then once charge is framed is when the trial really begins, and that's settled law. So once the charge is framed, you will have prosecution evidence, you will have defense statement of the accused, defense evidence, final arguments, judgment, and sentence. So these are the broad stages, and we are really concerned with the second part, which is the part relating to post-framing of charge. But I would also like to dwell with the issue regarding supply of documents, because that is going to become a very important issue. So let's say an investigation is done in the post-COVID era. A person is arrested, not arrested. How is it going to proceed? We must understand that India is one, but all courts don't have the same infrastructure. For instance, the High Court of Delhi has many courts which are e-courts, permit e-filing. Some of the courts, district courts, are adopting e-filing. But we need to look at the 600 plus districts in India. Look at the remote districts, tehsils, blocks with rudimentary court infrastructure. I don't know if any of you are from Maharashtra, but about a year ago, I had gone to Maharashtra, and I appeared in a court in a place called Dharmabad. I don't know if you've heard of it. It's in Nanded district in Maharashtra, adjoining Nizamabad in Telangana. So I reached Dharmabad in the morning, and there was one courtroom, and the entire bar strength was 20 lawyers. The judge was sitting in his court. It seemed like a huge go down, which was converted to be a court. And when we went there, I noted that there were holes in the roof of the court. So the lawyers told me, I said, how do you manage? Because you have a monsoon. They said, sir, when it's in a monsoon, these are areas marked out where we don't stand. So this is the kind of lack of infrastructure you have. And if that's the kind of infrastructure that you have, then imagine trying to run an e-court there. And let me tell you, though it was one court, the judge had a number of matters. He was very efficient. He was dealing with all his matters. And those 20 odd lawyers were fairly busy. They had a lot of work, and they had a variety of work in the district court. It was not just, limited to one branch of law or the other. They had land acquisition matters. They had land matters. They had civil suits. They had criminal cases, because remember, this is a magistrate's court, so they didn't have sessions trial. And then this gentleman also had to send matters to the district where the sessions trials would go on in Nanded. So this is the kind of rudimentary infrastructure. We are looking at a great change where there will need to be a complete change in mindset, not only of the court, but infrastructure, which will need to be made not just fast. It'll have to be done overnight to make courts functional. Otherwise, we'll have a position where people don't have access to justice. Today, I'll give you an example. Different courts have adopted different softwares. So when I did my first hearing in the High Court, in the Supreme Court, I could see the judges could see me. The second hearing, I was in a remote corner of the screen where the judges could barely see me and I could barely see them, but we could hear each other. And the defense lawyer, the opposition lawyer had a problem coming on. And on the third hearing, we were there, but we managed. And finally, the software crashed. As a result, the hearing was done on WhatsApp, and I believe it's been reported in the newspapers. It's a case from Maharashtra where anticipatory bail was granted through a WhatsApp hearing because the judges were kind enough to switch to WhatsApp. The Delhi High Court uses a better software called WebEx, which is very good, and the hearings are much more better. But today, like our High Court rules vary, we have different softwares, different procedures, different formats. There will have to be a standardization for VC hearings throughout the country so that every lawyer, each time you are arguing in a matter in a different court, you don't need to go to a different software or a different technology and then have to understand and work your way around it. Even in the metros, I've told you of the challenges, the fact of not communicating properly, and we will need to have speed of communication. We can't have a situation where I am speaking, I'm arguing a matter, and my voice takes a few seconds to reach the judges because they're not hearing me or the voice is cracking. And that will become very crucial in not only conducting hearings, but more important, conducting evidence via video conferencing. There is another concern. An accused has a right to appear, as in fact is entitled to appear under 273 of the CRPC. Witnesses are supposed to be present under 137 of the Evidence Act. But can you can't really have a situation where accused and witnesses descend upon the court. That will really make it a mockery of social distancing. So if we try and do this in different places, that is, the accused is at his home, let's say he's not in custody, the witness is at his home, will the witness be free from influence, either of the prosecution or the accused or the complainant? So these are serious concerns and these will need to be addressed. And there are guidelines which are already there for deferring of evidence, so those will also have to be considered and followed. Also, I must tell you, we have a concern regarding the security of software. After all, this is going to be the record of the court. Just as you have written records, so if you have a problem with the court order, you have a written record where the judge dictates the order, and in the event there's a difference between the typed version and the typed version, you can always request for the steno's notebook to come, and that will indicate whether it's properly recorded or not. And then there's the question of identity theft. These are all concerns which are going to arise. Now let's talk about remand. Remand becomes important because whether at the investigation stage or post the charge sheet, chalan ke baad, at 309 CRPC, once cognizance has been taken, the matters to the appearance in court gives you access to counsel. In a recent matter where I'm appearing as a prosecutor, the VC, even in a special court, in a designated court, was taking time, and we would often lose a visual contact and a hearing which should take a few minutes in the trial court in the special court, where there is, I must tell you, there's outstanding VC, but we had technology and signal problems. The accused are in custody in jail, in Tihar jail, and in Delhi, if you're not able to hear it, what will be the plight in the district courts unless we buffer up the systems? Now, this remand becomes very important for an accused because when he comes, he meets his family, he meets his lawyer, he discusses with his lawyer as to the strategy, he gives factual instructions, he prepares for trials. I don't know if the advantage of interaction with your client is great. I don't know if you read a recent decision on quashment. It's called Shiv Kumar Jatia. There was a hotel owner who was facing a criminal prosecution, and during the course, something which had not come out in the investigation, during the course of hearing in the High Court, he told me that the day the incident took place, somebody fell off his building, and he was being prosecuted for rash and negligent acts. He was not in India on that day. So if he was not in India, he could not get the person to hospital in time. We placed those documents, but that was because there was a factual instruction that he gave me and because there was interaction. But remember this, if a person is in custody, this was a man who was free. But if a person is in custody, how will you have a secure client counsel conference? How will you know that the police are not hearing the instructions you're getting? Supposing the client tells you an alibi, or you want to create a defense, or the client says, go to X place, you'll get records of my presence, or go to Y person and they'll give you my defense documents. How will you do this? Remember today, jail visits are on hold. And in any case, even jail visits take 15 or 20 minutes. So if you're not having jail visits, accused are not appearing, remand and VC at the time of remand, the ability to confer with counsel will become most important, because otherwise a trial court counsel cannot prepare his trial. After all, you need a deep understanding of documents and you need a deep understanding of the processes of law. Look at the prosecution's problem. Prosecutors, as you know, are dependent on police support. They're dependent on the investigating officer, the Pairway officer, the Naib courts, who are police constables or police officers who come from the police station. And they have constant interaction with these people for explanation of the records, for obtaining instructions. Before trial, they need to assess credibility of a witness. They need to interact with the witness to see, will this witness hold up, or should I drop the witness? Trials, as we know in our country, take time. So if it's a delayed trial, you need to acquaint the witness with records, with documents, before examination in the court, especially when trial. If a witness comes, by way of example, and he says, "Sir, my eyesight is poor. 20 years ago, I saw the documents. Today, I can't identify." So the prosecutor will have to lead evidence to say that today his eyesight is weak before he's confronted by the defense counsel in cross-examination to demolish him, that he has no vision and can't see the records. These and other concerns will become prosecution concerns as time goes on, and prosecutors will be required to have adequate access. Of course, the argument is you can meet your clients with social distancing, you can meet the prosecutors, can meet the investigating officers, but will you have, if you have a VC hearing, where will the investigating officer be? Because the records will be in the custody of the court, the original records. So the court is carrying out its proceeding. The police officer is at the police station. The prosecutor is in his own room, which we know in trial courts, prosecutors don't have rooms also. And the Naib court is in the court. The accused, the witness is also at a third remote location. We have to determine a mechanism by which this interaction becomes more and more effective and useful. Now, let's just deal with our other concerns. Accused is arrested. How does he furnish bonds? How does the judge secure the bond that this man is going to appear? How will sureties be given? You need to travel abroad. You need permission to go abroad. You need permission. You need to modify a bail condition. Where will you go and appear? How will the bond be accepted? And then in criminal cases, accused are supposed to appear on each date, 205317. The recent Supreme Court judgment does not talk about personal exemption from personal appearance, though high courts are trial courts and high courts are trying to evolve methods. But if an accused is required to appear, and I believe some application has been moved in the Supreme Court to say that, look, you need to modify your order. I believe that's been moved yesterday or today. Then 205317 CRPC must be granted liberally or across the board in all cases. Otherwise, we'll have a problem. Otherwise, the whole purpose of social distancing is going to fail. Now let's understand. Let's come to the stage where you're about to proceed with the trial. 207, supply of documents, is a very important stage. We get and statements under 161, statements under 164. In a normal trial, we inspect this record. We see what is original, what is not, because if it is original, what is the source? Is it properly seized or not? Where does it come from? If it is not, we can actually challenge the veracity of the document, the reliability of the document, the authenticity of the document. We can challenge the chain of evidence. So therefore, it becomes essential to have access to a physical inspection of the original record. This will have to be facilitated. That is, you have to have access to the police report challan. Now, one answer can be you will get a digitized copy of it, but the digitized copy necessarily may not have quality. I'm doing a case, in the trial court, Companies Act prosecution, SFIO, where there is a voluminous record of about 30,000 pages. About 5,000 of those pages are not legible. The only way they can be seen is, we've tried photocopying, we've tried scanning. The only way they can be seen is by a young lawyer going and inspecting them one by one and finding out what is in the original and what is in the original document. Some are carbon copies, some are faded copies. Then also, even if the charge sheet is filed, you have to see whether documents which prove the innocence of the accused, exculpatory documents, they've been seized, but have they been suppressed from the police report? Now, if you all read that decision in Nityananda, the case from Karnataka, that Swami, I had happened to be amicus in that, there it was decided that accused are now entitled to get exculpatory documents. And you can bring them at the stage of consideration of charge. You don't need to wait till trial. So if that can be done, inspection and access to the original record becomes important, and that will require physical presence. And then verify existence and sanctity of material objects. I'll tell you, let's say there is a weapon. The weapon is in a packet. Would you not want to see whether the chain of evidence, whether it's sealed properly, whether it's not sealed, whether the deceased or the accused clothes, which bear, let's say, offending material such as blood in a murder case, have been properly sealed and kept, whether the chain of evidence is intact? In a normal criminal case, material objects are kept in the custody of the court. I'll tell you an anecdote. It sometimes is at the point of ridiculous. There was a gentleman called Amarmani Tripathi, a minister in UP, who was being prosecuted. I was engaged by the CBI the year 2012 to argue this matter somewhere in about May. So I went to Nainital because nobody wanted to argue it. It was a very bulky record. And the hearing went on for about 5 days in Nainital. Lovely place to do a hearing though. But I was there for 3 days once and then 2 days once, just for the hearing. Preparation was separate. And while I was going through the record, I was looking for the weapon and I found a jar. I was very surprised as to what this jar contained. The jar contained the fetus of the deceased. The fetus taken out from the body of the deceased, which had been put to a DNA test, and that was part of the material objects, and that was kept in court. Needless to say, after touching that, I had no desire to have lunch. So the hearing post-lunch went out on an empty stomach. But one has to see material objects, and that is why I was making a point. We also have in criminal cases, as in civil cases originally, we have admission denial. Now, 294 CRPC requires the presence of either the party or for admission denial. This will have to also be worked out through video conferencing because this becomes important. And let me tell you, even at the stage of charge, an accused has to appear to record a plea of guilty, not guilty. If it's going to be done by video conferencing, going to make that plea. In a magisterial trial, the accused has the right to make a statement. Case, how will that statement? Well, if it's going to be a plea of guilty through VSBC, it's going to be statement to be recorded. Now, this plea of guilty is very important because tomorrow there will have to be a security and systems, and when an accused or a witness goes into a room where he gives this plea, which is electronically recorded in the court, how safe is that room going to be, which is going to be a room of multiple users? If you speak to a lot of the reasons the hospitals are not functioning and doctors are not functioning is because especially doctors dealing with dentistry, doctors dealing with ear, nose, throat infections, doctors dealing with eye infections, doing surgery, there is of cross infection. A room which is accessed by many people, witnesses or accused or others, may lead to cross infections. Until the whole country, we don't know who's a carrier, who's not, because the statistics, 80% people may not feel symptoms but may remain carriers. So therefore, we have to also evolve. We'll have to consider mechanisms of how this is going to function. Presence of the accused, again 313, will have to be through a VC, but there has to be an ability to confer with counsel. As we all know, under 313, normally the judge is supposed to write the questions, but the prosecutor prepares the questions, and then the lawyer dictates the answers. I've seen so many trials where it's really the lawyer dictating the answer and not the accused, or sometimes judges insist. And in any case, at the 313 stage, lawyers can confer with the accused to give the. So how will you do this conference where the lawyer and the accused have a back channel where they can have a secure conversation without it reaching the court? And yet the accused is also speaking to the court. So these are technological issues which are going to arise in the post-COVID video conferencing courts, and the video conferencing courts seem to be the mechanism how we will pick up functioning again. As I said, during evidence, presence of accused, his advocate and prosecutor, and interaction with witness. Very often, when a person is in court, there is a certain solemnity, there's a certain importance which is attracted. He's supported with his own advocate. So his advocate, if it's a complainant, evidence, or if it's a defense advocate, cross-examines on behalf of the accused, he takes instructions and keeps putting questions. And the prosecutor, and this interaction so far has been very important because it can either create an apprehension in the mind of the witness or a confidence that the prosecutor is with him. It's a confidence, and also the accused lawyer, the defense lawyer, the physical presence, prosecutor conducts examination and cross-examination to determine the psychology and mental makeup. After a few questions, it becomes clear which way the witness is going. Because you can see the witness sweating if the witness is in trouble. You can see a witness shaky. This becomes important because under 280 CRPC, the demeanor of a witness is recorded, because that becomes very crucial. The demeanor is not recorded by the trial court. The appellate courts don't have the benefit of understanding, appreciating to what extent the test should or should not be believed, and demeanor is an important test. You want to confront a witness with documents. Section 145 of the Evidence Act permits confronting a witness with previous statements in writing. Now, how do you do that? This will also have to be seen, because this is very important. How do you prove improvements? How do you prove contradictions? This will also have to be done because you will have to put original documents or records or 162 statements. Because today, I'll tell you, practically in the court, in an appellate court hearing, we often produce documents over the table. Till recently, we didn't know how to produce it. So in one case, I flashed a document in front of the camera. But in the second hearing, the judge said, please send it to us on WhatsApp. But these will also in future have to be secure communications. There's another problem. VC means normally one speaker at a time. So a question may be asked and answered before the objection can actually be recorded. Of course, there's an issue of marking and exhibiting of documents, but that's really a court concern. And eventually, we must understand that VC hearings are time-consuming processes. The speed of a physical hearing will not be achieved. So we will also, trials will take time. It's not that trials are going to be easy. Of course, on the other hand, you and I will be sitting in the advantage of in the benefit of our homes and doing it. And we will also have to be in court robes, because in the last couple of hearings, I found that judges were not in court robes, but I was informed that I had to be in complete court robes. So though I was wearing court robes, I was wearing my rubber slippers below, and I was very, very scared if I was asked to stand up and the judge was to see me in rubber slippers. That perhaps would not have been very amusing, would it? Challenges during cross-examination. Sometimes defense counsel may adopt a line of cross-examination which can be questioned by a judge as to relevance. In a courtroom, judge may ask the witness to step outside the courtroom for a few minutes in order to let the defense counsel explain. In VC, this can be muting the button or disconnecting the camera, but it sometimes gets a little time consuming, and this will improve as technology goes. Who will refuse? A question is asked, you want to raise an objection as to relevancy. A document is placed, you want to raise an objection. The judge says, look, I'm allowing it. We'll consider it. Traditionally, what you would do is you would have an application ready, a miscellaneous application, where you would feed in the question answer, handwritten application, tender it to court. Today, this approach, because you will have to have a mechanism. So the judge may say, I'm not allowing you to give it by WhatsApp. So you will have to have the ability to be able to place material on record, which is important. And as I said, the court atmosphere is very crucial. The solemnity of a court will have to be replicated for a witness to understand that the oath they are taking is not just a paper oath. As I said earlier, to 16 case that I'm doing, which is a trial case, which is that Bush and Steel's Companies Act prosecution. One man is in custody. Apart from him, there are 286 accused. Imagine to have 286 connections for accused to watch, 286 perhaps junior lawyers, 287 junior lawyers, 287 accused, one of course is being in jail, 287 lawyers, 287 senior lawyers, because lawyers may also not be sitting together in this COVID era. But let's say the lawyers can sit together. You can't close because that would destroy social distancing. So you have to have separate connections. So 287 accused, 287 junior lawyers, 287 hopefully senior lawyers. We need briefs also, guys. 280 prosecutor, investigating officer, court staff, and large screen. Today, the experiment of separation has been tried in vulnerable witness courts, which exist in districts in Delhi and some other places. But these two require people, individuals, to attend the court complex. The only distinction is witnesses don't physically confront when accused, but the crowd in the court doesn't listen. You still have the same number. It's not the change. Timing for each VC will have to be fixed. Fixed slots will have to be given. Today, fixed slots have been given. And that's the advantage. Young lawyers will excel. Young lawyers will have the opportunity because lawyers who are otherwise very busy, today you have lawyers running from court to court and adjusting matters. That opportunity is going to go away for the senior bar. You'll have to be to a few hearings. You'll have to go back to the traditional practice, like my late father, where people would take 3 or 4 matters a day because they didn't clutter up the board. For 2 or 3 hearings in the morning, that was it. Today, we find people doing multiple hearings, multiple trials in the same day. That will all have to change. Examination of witnesses enhances the level of protection to witnesses and witnesses, for example, children, people who have suffered violence. It also allows lawyers to sit wherever they are. So lawyers sitting in Delhi can try, or vice versa. Or in the Northeast can do trials in Gujarat or in Delhi or in Bombay. If you're talented, you don't need to travel. Expert witnesses, IOs often don't come. Today with VC, you're going to save all that time, and it's going to be a lot more convenient to the witnesses and the accused. There's going to be a problem on how to pay diet money, but that can be electronically managed. And you're going to speed up the processes. Sometimes you go, you're ready, you block yourself for a certain trial, and you go to court and you find the witnesses are not come. Official witness, the doctor says, The forensic gentleman says, I'm busy in an official meeting. The doctor says that the forensic doctor says, I'm not coming. Now, these issues are likely to these problems of physical hearings are likely to be reduced by VC hearings. Recently, we had Mr. Harish Salvi sitting in London arguing a matter in the Delhi High Court. Now, if he can do it from London, why can't we do it within the country? And therefore, the junior bar will have the advantage of being able not only to be available in their own bars, but in other bars. All lawyers will have that benefit or advantage. Of course, the airlines and the trains and the fees is going to be reduced because you're doing a hearing at your own court and you don't need to travel. So that's going to be a change. But that's part of the game. For young juniors, you can't often be present in the court because courts have limited physical capacity and lawyers are busy. Now they can't go. So VC will have to be fine-tuned to give young members of the bar opportunity to link up or observe more proceedings and enhance their skills. Now we know that live streaming in the Sahara case has said that it's not going to be, it's not the norm, it is an exception. But to ensure that the open court principle is not deterred, we will have to have live streaming of hearings, and that will have to become possibly the norm. It has its aberrations. We will become perhaps like the American lawyers will become show people, showmen and showwomen. But that will be part of the exercise, because today, how will you ensure the open court principle for every participant and for people who want to be aware? Recently one of my colleagues was speaking about how he learned trial. And he learned trial by going to and sitting in courts where great lawyers would come and cross-examine, and that's where he developed, and then he got opportunities, and thereafter he improved his trial proceedings. Because if we don't have that, we'll deprive the junior bar of learning from observing experienced lawyers, even though they or their seniors may not be engaged in the matter. In the initial years of the bar, when we didn't have so much work, what would we do? Whenever the opportunity presented, we would hear that some important famous lawyer is coming to argue or cross-examine, and we'd go and sit in court and watch, hoping to understand what is this genius going to do, what is this great man going to do, and would make meticulous notes to try and understand the line of argument to the line of evidence. But all of this is not going to be possible because what it will need is technology. Asking the correct questions, gauging the response is key to cross. Therefore, good sound video quality, internet speed. Bombay High Court has issued certain minimal requirements, which you'll see on this slide. Internet connection of 2 Mbps, laptop, desktop, laptop or phone to be identified by the name of the advocate, wide earphone, etc. I was speaking recently to Vodafone. I represent them occasionally, and I asked them, I said, listen, forget Wi-Fi, forget wireless connections, internet connections. I can't even hear myself in the phone, and you put 3 boosters in my house. So the answer was, we are not being able to import equipment because of restrictions today. And the fact that our systems that are surviving today is a miracle, because everybody is now using the internet. So these are challenges, and we'll have to buffer up our system. Government will have to release more bandwidth. We'll have to go to 5G and 6G if necessary to ensure that technology, that the same amount of wavelength, same amount of data, much more data can be put on the existing waves. We'll have to have in criminal trials dedicated days, timings for holding hearings. This will be important. In Kerala, there's a very interesting system. They follow the old principle of 309 CRPC, where they defer a trial for many months, and once the trial begins, it goes on from day to day. Now we'll have to adopt that policy in India. We'll have to have more judges. If a judge can only do, let's say, 2 or 3 trials or 5 trials in a day, 2 or 3 trials in a day, or 2 part trials in a day, you'll have to increase the number of judges. You'll have to increase the number of courtrooms. And that's going to be a great opportunity for young lawyers, because today, joining the judiciary, for those who are interested, I was told the other day, the starting salary is 80,000 rupees as a magistrate. And the terms are much better than they used to be 20, 30 years ago. We'll have to change from physical copies because physical copies today are filed in court. As I said earlier, there has to be a standardization. The Supreme Court was looking at standardization in the physical form, but today the rules of the high courts will have to be adapted. E-service is already becoming a norm, becoming adopted. This will have to become the norm now. Adequate training for advocates, for clerks, court staff, at every district, at every mufassal, at every magistrate's court in the country, at every civil court in the country will have to be done. And will end up being the responsibility either of the government, state governments, or of the high courts to make sure that people can ramp up capacity, because while you and I have access, a lot of people don't understand. Clerks and court staff in the district courts will have to be trained. Advocates' homes, offices will have to be better improved. Legislative and regulatory changes must be effected across the board in every court for immediate implementation of these systems. The way forward was defined in Praful Desai in 2003, where they said VC can be done. The court observed that the code, the CRPC, the Evidence Act are ongoing statutes, they can be interpreted. The shift to trials, online methods with live streaming must be viewed as a natural outcome of the continued evolution of the justice delivery system. But having said that, we must remember the most important element in the justice delivery system is not just lawyers, prosecutors, police officers, judges. That is the person who comes to the court or is in the court to seek delivery of justice, whether he be an accused or he be a victim. We will have to ensure secure environments for them to be able to access and to see the hearing, because you will find there are people who can't even afford a mobile phone. If access to justice is a constitutional norm, then surely we need to ensure that they who are the beneficiaries of the legal system, the criminal justice system, must get access to justice, and they must be able to see what is happening in their proceedings. With that, I'm going to end today's talk. Thank you very much. And now we will proceed to a question-answer session.
Thank you very much, sir. In fact, it was a very, very detailed lecture, and we all have listened to it very, very carefully. In fact, our viewers have thrown up a lot of questions, very relevant, and I will be taking them one by one. For our viewers, who is Mr. S. and he's asking you, sir, whether criminal trials through video conferencing are done in any country. If so, how is it being managed? So he's curious to know how is it being. He's asking, sir, whether criminal trials through video conferencing are done in any other country, and if so, how is it being managed? So he wants to know the international impact of it.
I think so far we've been using video conferencing for limited proceedings on the commercial side. Arbitration hearings are done. Some international courts have adopted video conferencing. And these are for recording of evidence, let's say on commissions or evidence of witnesses who can't come, or letters rogatory examinations. So that's the kind of limited use there has been. I'm not aware of any comprehensive criminal trial being done on video conferencing as of now in any jurisdiction. Therefore, as I said, whether in India or elsewhere, because this is not going to be a change limited to India, this is the change which is going to be pan-world. And once it's a change pan-world, we'll have to evolve systems, and the most important part is regulatory changes. This is not just about Archana, and friends, this is not just about changes limited to procedures. There has to be a recognition of these methods, and that's the reason I've raised some of these concerns, because according to me, there has to be a larger consideration.
Right, sir. There is another Miss Rachita Chawla, and she's asking you, sir, but technology does not always come handy for specially able people. So how would one cater to that?
I think that's a very important question. Uh, for people who we will have to have interpreters, just as we have interpreters or court assistants. Traditionally, if you would, I don't know how many of you recall. Well, I'm of a little older generation. There used to be translators in every high court. There is a translation branch in the Supreme Court, though now really redundant. And that translation used to be done of each testimony, and records which were in vernacular used to be translated into English, or records in regional languages used to be translated. Supreme Court had a very effective translation department. But today we've reached a position where those translation departments have become redundant. So therefore, we will have to provide a mechanism by regulation, by high court rules, which is the fastest way, or even by legislation through ordinance, providing for interpreters for differently abled people, so that there is a fair trial which is provided to them.
Right, sir. One Mr. Divjot Kaur, she's asking, can technology hinder transparency? Now, this is something because we already discussed.
Sorry, I missed that answer. Can I have that question again, please?
Yes, sir. So one Miss Divjot Kaur, she's asking, can technology hinder transparency? So here, I think she's really bothered about, when we were talking, sir, you were talking about the witnesses not being perturbed by the presence of accused, or how could we do that? So she's asking specifically, can technology hinder transparency?
I think that's something which is an ongoing process, and that is a concern which I believe is very valid. Look, the fact is, technology is going to be here to stay. We may be fortunate that we in India, we've been very fortunate till now with the way the government has acted, with the fact that we've had a lockdown and we've escaped with a large number of cases. We're not like the US or Europe, and therefore we are much safer. However, the concern is that technology is here to stay. And as Ms. Kaur rightly says, there is a concern regarding transparency. Now, one of those concerns can be met by providing for live streaming of the actual court proceedings. However, in terms of access to the record, access to documents, we'll have to create a mechanism of secured environments where a lawyer can remotely inspect records. That's to be seen, where a lawyer can have a conference with his clients, because as I said, one of the issues is client confidentiality where a person is in custody. So in this new look era, like my new look today, we will have a time where we will have to change. And in life, as in law, change is the only constant.
Sir, Mr. Madhusudan Joyal is asking the next question, and he says, sir, how long changes of this system will take in all the courts? Very difficult.
You'll have to ask the law minister. That's a simple answer. But the more complicated answer is, we will have to immediately, and when I mean immediately, I mean it's a matter of serious concern, we'll have to evolve mechanisms on an expeditious, on a priority basis, because today access to justice is being deprived. While the courts have been, the High Court and the Supreme Court have been good, even the trial courts in terms of bail. I got a bail because they said, because of COVID, we're giving you anticipatory bail. That's how I got an anticipatory bail order. And the merits of the matter will be considered later. Because police said, we can't arrest this man. If we arrest him, where do we take him? But that apart, but that's an individualistic approach, of course. My concern is much larger. We need to provide this buffered mechanism, at least in the court system, and we need to make courts available. We will have to start. I believe the moment the lockdown eases, access to justice has to be a priority. It cannot be on a back burner. And we're looking to the Law Ministry and the Department of Justice, and we're looking to the courts to lead that way. As I said, the Delhi High Court is opening, but I hope and believe that all the other high courts will follow. and just lights. And I hope that there is going to be a change sooner than later.
So there's another one coming from Muhammad Kamir,
I'm
and
getting the question. Please read it out, but I'm getting the questions.
yeah, he's saying, sir, don't the live session have the threat of hacking and other cyber criminal activities? You mentioned about hacking the softwares and all these issues.
I think it's a very important issue. As I said at the earlier part, there has to be a secured environment. Without a secured environment, we are going to have problems, because this is, originally, what was the biggest concern in courts? That the physical record should not get destroyed, isn't it? So we have to have an environment where the sanctity of that record remains, and that electronic record is completely secure. And of course, the courts will have to keep physical backups also, because that will be the backup of the record in the event tomorrow there's let's say, a cyber warfare or a hacking situation, and that's a concern.
Right, sir.
Yes.
Mr. Ritu Saha asked a question, sir. If I'll just read it aloud, or if you can just answer it. It's about technology and substitution with physical appearance.
I think, Mr. Saha, I've tried to raise the same point. I have a concern. I have a serious concern about it, because physical appearance, there is a certain aura to court. There is a certain solemnity to being present in court. We as lawyers conduct ourselves in a certainly different manner. I can share with you, in my recent hearings, I found that some of the arguments that are addressed when you're sitting in the comfort of our own homes or offices, as the case may be, I find that their language is becoming a little casual, because we are also not in courts, and that's an issue. So that, I think that will have to be dealt with and replicated in a manner so the way a witness is sworn in, the fact that the witness is informed that this is no less than a real court, that you're going to be prosecuted for perjury, you can be, if you misconduct yourself, or action appropriate or other action can be taken against you as deemed appropriate by the judge. If you otherwise conduct yourself obnoxiously while recording evidence, or if you are found to be carrying documents or not giving fair testimony, or being accessed by any party during the hearing. So all of this will have to be considered.
So the next one is from Mr. Saksham Malhotra, and he says, don't you think we have VC rooms in every district to ensure proper statements being done by the...
I think just individual rooms is not going to be enough. Let me put it to you differently. Let me put it to you this way. A lot of people ask me why I've got my hair cut, and I said, I'm not going to be going to a barber for the next 6 months. Now, why will I not go to a barber? Because of cross-infection. The moment you have a room where a person is going, the dangers of cross-infection, that is, A infected person carrier gives it to B, who is not a carrier but who goes there for hearing. Now, today we know for a reality that people who are immunocompromised with lifestyle diseases of a certain whose lungs are compromised, or the aged, have a concern in terms of being exposed to infection, because they are the most vulnerable. If that be the case, just individual rooms is not going to be enough. We'll have to have multiple rooms and multiple accesses to ensure that social distancing norms are maintained and infections are controlled at the highest level. Otherwise, we'll have a lot to answer for from the criminal justice system.
So the next one is
Archana, we missed a couple of questions in the middle, so if you want to ask them later, because they were flashed, I saw them, and then we moved on to another question.
Right, sir. We can take the present one right now, and then we can go for the other questions that we have missed. So this one, I think, is really apt. He's asking about the mandatory registration of FIR post-COVID-19.
A lot of jurisdictions have permitted online registration of FIRs, and even NCRs. Non-cognizable reports are now online. So we'll have to have mandatory registration FIR. But then the question will be, the police will have to consider, do they really want to arrest people so often? That's a serious issue, because remember, in our system, and this is peculiar to India, maybe to other countries as well, but India, of course, the number of under trials is much higher than convicts in custody. So today the CRPC will have to be revisited to say that only in the most limited of cases should people be taken into custody when there is no other option. Secondly, in the heinous crime, by way of example, or where something needs to be recovered. And then again, instead of overcrowding in bails, in jail.
I think there's some problem at Sir's end. Yeah, you were discussing rightly about the overcrowding in jails. In fact, there's a matter there.
I
We
would say,
have recent deliberation on the matter by the Supreme Court also during this lockdown era.
yes, there has been, and I think we started looking at changing the mechanisms for under trials. We don't need to flood our courts, jails with under trials. We have to relook at that philosophy where kept in custody as under trials simultaneously. And this is a little important. We also need to consider that people who are that the policy of will need to change. Today, and I'll say this very frankly, as a I appear as a prosecutor, I've appeared as a witness in a criminal trial, I've appeared as a defense lawyer, and those three roles I've had experience of. And I must tell you, the problem that we face is that the moment a crime is committed, everybody is baying for blood. So perhaps investigations will also have to be done with minimal arrests, leading to minimum petitions for bail or anticipatory bail, as the case may be, as it used to be traditionally 30, 40 years.
Right, sir. In fact, there were 2 or 3 questions about the Special Act. I mean, people were asking about the POXO Act, the trial of the POXO Act. Is it really possible?
Yeah, the POXO Act. Well, POXO, you already have vulnerable witness courts doing POXO trials. So the same mechanisms will have to be evolved, except virtually. So POXO in fact, POXO, it's just creating the same mechanism except at remote locations rather than at one location. So that's one part. That's actually quite feasible to get for a POXO trial. Now, yeah. So what is the other question?
So, Mr. Bose is asking, how do you see VC after 5 years from now? Mr. S. K. Bose, he's asking, how do you see video conferencing 5 years down the line in India?
I think hopefully when this COVID issue is over, and from what I understand from doctors is that unless still the vaccine is found, it's not really going to go away. So as time goes by, we will become more and more adept at video conferencing. I think it's in a lot of ways, it's a lot more efficient. It's a lot more logical. And we will adapt to this new technology. 5 years from now, it may become, if a COVID cure is found, hopefully in the next year or two, and we are back to almost business as normal, I hope that there will be a system of physical trials or VC trials. And if we can replicate the solemnity of a real court in a VC hearing, then perhaps VC is the way forward.
Right, sir. There is one more question coming from Mr. Venkateshwar Rao. If you can see it on the screen, sir.
I can see it on the screen, in the question. Okay. So I think it's I've raised this issue of demeanor. These are issues that are going to arise as to recording of demeanor, and 2 things may happen. One, the judges will have to be extremely observant. As I said, the technology will have to be very superior. The judges will have to be extremely observant. A lawyer will not have the advantage of seeing a witness necessarily sweat because on camera it's not always easy to see at a distance and in an air conditioned room or environment. But lawyers will also have to work harder at observing the body language. Look, in court, you see the whole body of a person. You see whether they're twitching, whether they're shaking, whether they're jittery, whether they're moving. But there, you will only probably get to see the torso, the upper body part, or only the head. So we'll have to become masters at facial recognition or facial psychology.
Right, sir. There's one coming up from the FB page as well, and I will read it, sir. Mr. Sanjeev Prakash Upadhyay is asking whether an amendment is possible under Section 161 CRPC, where signature of the person whose statement is usually recorded by an investigation officer is not required, which is serious question of reliability of statement.
Look, that's the issue regarding recording statements. Getting signatures on 161 is a matter of concern because 162 prohibits it. So, except now there are video recordings done for certain class of offences. That amendment has been made to 161, 160, 161. So, barring those class of cases, you do not have 161 statements recorded or signed by witnesses. That being the situation, that amendment is a larger issue. Do we want such an amendment? Do we want to give a police officer's version so much sanctity? And then again, that may be obviated if police officers start recording statements on video conferencing. Then that whole idea of signing of statement will end, and we will move into a different era, and we will have to then test that statement based on the video recorded version or the orally recorded version, the electronically recorded version.
So Mr. Ravi Kajagar is asking how you spending the time, how are you spending the time in this lockdown? What are you reading? I think just off the cuff question he wants to ask.
I'll give you the answer. Look, I am. It's a blessing in disguise. I recently had a loss in my family. My mother passed away, so we are spending time with the family, and that is wonderful. That's one part. All meals together, lots of time together. We walk together, though maybe within the house or just immediately outside the house on the road, but we're spending that time together. That's the family part. The second part is about 2013-14. I had a passion to learn Urdu, so I learned to read and write Urdu. At that time, my mother had told me, she says, your father used to read and write Urdu, so you learned Urdu, but I learned Sanskrit, now you must learn Sanskrit. So I'm on my 15th lesson of Sanskrit right now. I do an hour's lesson every day through video conferencing, I'm trying to learn that language. It's a great privilege and honor. Maybe I'll be able to read and write like I read and write Urdu, English, Hindi. One day I'll be able to read and write Sanskrit as well. I'm reading a lot, and I've been writing a number of articles. So Kirti and I, my wife and I, have been co-authored 4 articles written in the HT in Times of India on current issues, on legal issues. Now we've started a weekly column in the Sunday Guardian. First was published last Sunday. We'll be doing it fortnightly, I hope. So that's an interesting part. Apart from that, a lot of non-legal reading, some legal reading, a lot of non-legal reading. I've cleared up my old family record, my albums. I went back and found the records of my grandfather when he came in as a refugee in 1947. I sorted out all those papers. They're family heirlooms for us. And that indicated the struggles my father and my grandfather had. My mother's side had. Some of those records are there. So that's been partly personal, partly intellectual, partly relaxation, partly family time, partly learning a language. The idea is to keep oneself busy, but not so busy that you're overcrowded. My late grandfather, used to tell me a couplet, and I'll recite that for you. It's in Hindi, and I'll translate it. The simple, it says, "Hey bande, bekar na bash." Bash in Persian means bet. "Hey bande, bekar na bash, kuch kiya kar. अगर कुछ भी ना करे तो kapde hi udher kar siya kar. Translated, gentlemen, don't sit empty. Don't sit without any work. If you have nothing to do, take your clothes, open the threads, and then stitch them back again. To put it simply in English, an idle mind is a devil's workshop. But an overcrowded mind is not necessarily a great thing. So keep time for thinking, for contemplation. I am reading, I've read a interesting book which I concluded recently, and now somebody had given me, one of the members of the Vodiyar, the Mysore royal family, had given me a history of the Vodiyar royal family. So I'm reading about the chapters and the the origin. I've read the chapter on Tipu Sultan and Hyder Ali. I'm going to read the chapter on Tipu Sultan today, and tomorrow thereafter the regime after Tipu Sultan, their interactions with the British, Tipu Sultan's interaction with the French. So all of that is an interesting part. I enjoy reading history, so I'm enjoying that, and that's what I spend my time on. What you want to do is your choice, but give yourself me time, give yourself family time, and give yourself time to contemplate. One of the things I want to tell my young friends here, Archana, I'm sorry, I'm going to take 2 more minutes.
No,
You
sir,
give
it's
a
fine.
lawyer, you give a lawyer a mic after so many days. So कुछ तो मैं बोलूंगा ना. You can't stop me. It's difficult for me to stop. So I'll tell you, one of the things which is important is work is going to be lesser till the courts buffer up. Work is not going to be, we are not going to be doing the number of matters. So for the younger bar, look for opportunities. But even for those who are going to come in now, fresh lawyers, today, let me tell you, the last 4 hearings I've done, I did not need a junior. I managed it myself because there were limited hearings. The brief came to me electronically. I saw it digitally and I argued them out. So there is going to be an issue regarding the number of juniors, young lawyers or lawyers who would get opportunities in law firms and senior offices. Though on the corporate side, perhaps there's going to be a lot more opportunities in work because there's going to be a churning of the economy. And they are very happy working digitally. But there is going to be a change. So we must think about it, contemplate, and adapt to that change. And that is my recommendation for my young friends. So think about the way forward. Okay? And let me tell you, it's going to be a great way forward. The photograph behind me is that of my late father, Mr. K.K. Luthra, senior advocate. He passed away in 1997, 2nd May 1997.
I must tell you, sir, this was indeed a very, very nice lecture, and we all learned so much today. Hearing you live after so many days is indeed a very nice experience. We must tell everyone that Mr. Sidharth Luthra also teaches law in India and abroad. So he's a visiting faculty, he's a visiting professor at Northumbria University at Newcastle, United Kingdom. He is also, a very distinguished senior advocate. And in July 2012, Sir was appointed as the Additional Solicitor General of India. And he's represented various union and various state governments in matters relating to fundamental rights, so on and so forth. I know, sir, you don't need an introduction, but as my duty, I'm just, saying a few words. Thank you very, very much, sir. We are indeed enlightened, and I also want to thank my viewers, my bottom team, which is supporting day in and day out. With that note, I must also tell you, sir, that for today's lecture, we have the pamphlets, everything digitally sent in various languages, Hindi, Gurumukhi, Telugu. So, it has reached actually in all parts of the country. We have, so many viewers. I would also request everyone, to contribute generously to PMK fund, maintain social distancing, and make maximum use of this time that we have got. Unprecedented times, but then we can make use of it. Once again, thank you very, very much, sir. I would also request my viewers to please like, share, and subscribe our channel And subscription does not actually mean you have to pay anything, it is free. So it's just a way of forwarding a channel to maximum possible people so that they can have the maximum benefit and advantage out of it. Thank you very much, sir. Thank you. Namaskar.
It's been my pleasure. Most grateful.